Hi everyone, we're just waiting for a few more attendees and then we will get started today. But we're really excited to get into it. All right, that looks like some good numbers there. So just wanted to start with a good morning to everyone. Thanks for joining, and it's so great to see so many people with us. We just wanted to start with acknowledgement of country. So Employment Hero acknowledges Aboriginal and Torres Strait Islander peoples as the first Australians and the traditional owners and custodians of which the lands that we work and live. We acknowledge Aboriginal and Torres Strait Islander peoples' continuing connection to country and pay our respects to their elders past, present and future.
Good morning, everyone. Welcome to another Employment Hero Masterclass where we break down complicated entitlements and obligations under the Fair Work Act into more easily digestible information. My name's Georgia and I'm a team lead within the HR advisory team here at Employment Hero.
And I'm Amy, a senior HR advisor within the employment team as well. Before we jump in, some housekeeping to start. We've allocated some time at the end of the webinar for your questions, so please type your questions in the box down the bottom using the Q&A function. We'll have Annie from the advisory team answering the questions that come through. For those that we don't get to, we'll endeavour to answer after the webinar. I'd also like to note that today's session is being recorded and the recording and slides will be made available after the webinar has concluded. If the webinar inspires you to access further HR support, we'll have some contact details at the end for you to get in touch with our team. Finally, we touch on the general process for managing remote teams. However, these matters can become quite complicated in certain circumstances and not all scenarios will be straightforward. Sometimes it is the case you may need to seek independent legal advice.
Thanks, Amy. Now we will go into the topics today, but before that, we've got a poll up on the slides. If you could just hit what best describes your business's current work model, if you're working remotely or if you're in office. We'll give you guys a little bit of time to answer that one. Perfect. Thank you all for answering that. Now we'll jump into the agenda and the topics for today. So as you can see, the agenda is there up on the screen. And obviously it has been more than 4 years since the COVID-19 pandemic first disrupted the way that we work, which sent millions of employees to do their jobs remotely. Data according to the Australian Bureau of Statistics from 2023 captured that 37% of Australians are actually working from home regularly. As this is such a foreign concept for businesses to navigate, this new normal way of work can present a range of opportunities for businesses. As an example, a commonly seen benefit of remote working is the increased work-life balance, which means that workers can start and end their day as they choose, as long as their work is complete and leads to strong outcomes. This control over your work schedule can be invaluable when it comes to attending to the needs of your personal life, whether it be, dropping your kids off to school, running some errands. All these tasks are so much easier to balance when you work from home. We'll delve into this a little later on, but some further benefits that our clients have found by promoting a remote-based team include having the ability to provide job opportunities that aren't limited by geographic location and cost saving on things like rent for office spaces. With the list of positives that come from managing remote teams also comes some challenges that may arise. An example of a challenge that we'll discuss today that commonly does occur from our clients is managing performance and misconduct within the workplace. Having a remote-based team means that you can no longer see them potentially arriving late every day or leaving early. The only real indication that you have of your employees performing their duties is the work that's actually being delivered and what happens if that doesn't meet your required standards within the business. Companies that did once thrive in that traditional office setting have found themselves grappling with how to effectively manage and support a dispersed workforce. We hope today to provide you with the skills and tools necessary so that you can, do this and understand this change successfully. So, to go over the agenda, we'll be delving into the following topics today. As you can see on the screen, the first one's understanding employer obligations for remote work home arrangements, navigating legal entitlements and frameworks, ensuring compliance in remote team management, addressing the unique challenges and benefits, strategies for managing performance and conduct in remote teams. And we've also added in some Fair Work cases in relation to remote work requests. With that, let's delve into our first topic for today, which is legal entitlements and framework for remote work requests. So, remote work can arise in two primary scenarios. The first occurs when a business has implemented a formal remote work culture, which allows the employees the flexibility to work either fully or partially from home. In this scenario, employers have the freedom to choose how they engage with their workers' environment. However, employees do not have the right to demand remote work arrangements. Employers aren't actually required to or obligated to accommodate these requests, as it is a business decision. But the larger technical topic that we'll be discussing today is when an employee has the legal ability to request a flexible working arrangement under the Fair Work Act.
Yeah, so as Georgia just mentioned there, under the National Employment Standards, one of the key entitlements is the right for eligible employees to request flexible working arrangements. Recently, the eligibility criteria for who can make these requests has been expanded, and a broader group of employees can ask for flexible work as long as they've been continuously employed for at least 12 months. This also includes casual employees, provided they're expected to keep working regularly in the business. As you can see on the screen, to apply for flexible work arrangements, employees must also be parents or caring for a child who is school-aged or younger, a carer as defined by the Carer Recognition Act, aged 55 years or more, have a disability, be experiencing family domestic violence, or providing care to an immediate family member who is experiencing family domestic violence. If an employee is eligible to apply for flexible working arrangements, their request should be in writing and explain what changes are being asked for and explain the reasons behind the requested change, such as caring for a disabled child. As a business, you do have a legal requirement that once you receive a request from an eligible employee, that you provide a written response within 21 days, outlining whether the request is approved or refused. It's also really important to genuinely consider an employee's request. We typically recommend holding a consultation meeting to discuss the request thoroughly. During the meeting, you should consult with the employee and make an effort to reach an agreement on the proposed changes to their working conditions before making a final decision to refuse the request. The consultation meeting is a really good opportunity for both you and the employee to discuss the flexible work request and the impact of the proposed new arrangement on the business. You should also consider potential solutions for managing the impact. We suggest that in the consultation meeting, you explain why the requested arrangement does or does not work for the business. You could propose alternative arrangements and then ask the employee to pitch other arrangements which may work for both the parties, and then take all that information away again and think about whether any of the proposed arrangements could work moving forward. As mentioned before, you can only refuse these requests on reasonable business grounds. So it's not just a simple no without valid reasons. Reasonable business grounds that may be that the requested changes are too expensive or that other employees' schedules can't be adjusted to fit the request. It could be impractical to change other employees' shifts or hire new staff. And the request could lead to lower efficiency, productivity, or negatively impact customer service. Fair Work also states that your business circumstances can be factored in when considering if the business has reasonable grounds for refusing a request, such as the business's size and nature. For example, if you're a small business with only a few employees and you get a request for reduced hours, you might be able to reasonably refuse this request because there is like a limited staff size that makes it difficult to cover shifts or redistribute work. So after the recommended following consultation meeting and further investigation into the request, if the business is still unable to accommodate any of the alternative arrangements, we recommend reaching out to us to discuss the next step, such as formalising a letter of refusal. In a letter of refusal, Fair Work requires some specific details. The letter must explain why the requested arrangement doesn't work for the business. It should also provide the reasons for refusal, outlining the grounds for it, and the letter should mention any other changes the business is going to make or state if there are no changes that can be made. And finally, the letter also must include how the employee can seek help from the Fair Work Commission for disputes about the request. We just wanted to reiterate how important it is to have reasonable grounds and explain reasons for refusal. As we see in a recent decision here, the Fair Work Commission ruled that generic HR responses aren't enough to establish reasonable business grounds for refusing a request. In a case involving FedEx, Fair Work Commission emphasised that employers must show a likely detriment to their business to justify refusing such a request. While FedEx highlighted benefits of in-person collaboration, it didn't actually provide evidence that working exclusively from home would harm productivity or efficiency. The ruling emphasised that employers must offer specific reasons and examples, not just general statements, when they're denying flexible working requests.
Thanks, Amy, for that. Now I'll discuss some benefits of remote work and also go into some research that we have looked into to support these benefits. I did briefly go over these at the start. As you can see on the screen, we've listed a fair few benefits. Some of them include cost savings and increased employee retention and happiness. We've also looked into some research conducted by the University of Sydney Business School, which involved an analysis of 8 organisations, all of which had an all roles flex policy. The research shows that flexibility is a key factor in attracting talent across all demographics, whether by age, gender, or job type. The study showed that offering flexibility isn't just about accommodating employees, it's a strategic advantage. From the research, experts also agreed that flexible work policies not only improve productivity and morale, but also boost retention and give businesses a competitive edge. Here at Employment Hero, we've also conducted our own research into remote working. A key takeaway from the research was that remote employees are enjoying the experience of working from home, which was 84%, and would continue to work from home regularly if given the opportunity, which was 92%. Ultimately, it contributes to them feeling happier and more productive in their roles. In addition to that, Australia's biggest mental health check, a 2018 study into the mental health of corporate Australia, found that almost 1 in 3 workers from a range of industries were suffering from forms of mental illness. Safe Work Australia also looked into that employees suffering from depression take 3 to 4 days off each month. And this loss in productivity costs Australian organisations a total of $6 billion per year. Of course, many factors can contribute to workplace stress. In saying this, it's fair to say that many Australians like to work remotely and are happier when doing so. Now, of course, with the benefits can come some challenges. As you can see on the screen, we've got 3 of the challenges there. However, there are some more. We've just picked these 3 to go through today. The first one is the risk of social isolation. As we know, remote work can lead to feelings of loneliness as employees are missing out on that day-to-day interactions and camaraderie that can come from being in a shared physical workspace. We don't have those face-to-face interactions. It can hinder teamwork, stifle innovation, and limit the exchange of ideas that are going on within the team. To combat this, we would encourage creating opportunities for virtual connections and collaboration as much as possible. So this would be encouraging regular team meetings. Maybe you could do a little huddle every day to catch up, doing virtual coffee breaks and video conferencing, basically any opportunity that you can have to have a video conference and connect. We would recommend that. Also consider using collaboration software to facilitate that communication. Some examples of them are Teams, Zoom, and Slack. The second one that we've got is blurred work-life boundaries. So obviously when working remotely, it can become difficult to separate the professional life from the personal life because your professional life is usually right where your personal life is at home. Without those clear distinctions, employees can struggle to switch off which can lead to a burnout and potentially a decline in overall well-being. To overcome that blurring of the lines, it's essential to set clear starting and finishing times and try and promote a culture within the team where employees are encouraged to disconnect from staying logged on outside of those hours. If you are noticing that your employees are staying on quite regularly after their finishing times and they are staying back, maybe it would be appropriate to have a discussion with them and figure out what's causing them to stay back so late. Are they struggling with their workload? It could be potentially a resourcing issue. You know, if they're taking on lots of work, it may be that the business needs to look at maybe hiring someone else to take on that workload. They're just some suggestions of how to kind of stop that from happening. And the last one is the technological challenges that can come. Obviously, that's something that can happen with remote work, poor internet connection, because it relies heavily on technology. And these issues can disrupt productivity and they can cause a lot of frustration. To combat these issues, we recommend investing in, the best infrastructure for your employees to do their job at home, providing them with the appropriate tools like, mouse, keyboard, making sure they have the right setup, and making sure they have access to things like secure networks and reliable internet connections.
Yeah, so next we're going to dive into what remote work health and safety really means, share some practical examples, and go over the risks about not complying with work health and safety duties. First off, you are responsible for ensuring your workers' health and safety, even when they work remotely. Work health and safety laws still apply to remote work settings, and while working from home might seem less risky, it actually introduces new challenges and hazards that need to be addressed. If these risks aren't managed properly, they can seriously impact your employees' physical and mental well-being and put the business at risk of workers' compensation claims or work health and safety breaches. As just mentioned, one of the main risks of not complying with the Work Health and Safety Act is workers' compensation claims. For example, if you've got an employee that's expressed feeling overwhelmed and mentioned workload or task management as a source of stress while working remotely, this could be a sign that they're experiencing excessive workload or work-related stress. This is really important because work-related stress is protected under general workplace health and safety provisions related to psychosocial hazards. If the stress leads to psychological or psychosocial injury, it could potentially result in a workers' compensation claim. To mitigate the risk of claims, we recommend reviewing the Work Health and Safety Act, but we've taken some general duties from the Act to consider for your remote workers. The first general duty is taking reasonable steps to prevent risk to health and safety, which can include assessing the work from home setup. If your employees are working from home, a reasonable step might be providing ergonomic assessments to help identify those potential hazards, such as improper desk setup or poor lighting. By addressing these issues, you can reduce the risk of musculoskeletal injuries or eye strain. General duty 2 is providing information, training, and supervision to your employees. You could do this by offering online safety training on proper posture, taking breaks, or setting up a safe work environment at home. For example, sending out guidelines on having safe electrical cords or using tools correctly. General duty 3 is consulting with employees about health and safety matters. A really good example here is by conducting those regular check-ins or having surveys where employees can raise concerns, such as potential hazards they encounter while working from home. This feedback could lead to changes like issuing company-provided equipment to enhance that safety or comfort for your employees. We also have some steps we recommend to further enhance remote work health and safety. The first one we recommend is to hold those consultations. This could look like engaging in discussions with employees to discuss potential hazards and assess the effectiveness of implemented controls. Employees are typically the best judges of their own risks, so we highly recommend scheduling those regular check-ins with them. Just because they're working off-site, it doesn't mean they need less feedback, direction, or support than your in-office team. The second point is work design, which means only assigning safe tasks for your remote workers and setting appropriate procedures. This might include involving supervisors on challenging calls and ensuring that employees know how to handle abusive situations. Additionally, we really recommend offering an employee assistance program. It's a really great way to support your team, and they are like confidential counselling services that help the employees manage both their personal and work-related challenges, and it just ensures that they have the support they need no matter where they're working.
Amy, now we'll move on to exploring the compliance considerations for employers in a remote work environment. As more businesses do adopt a remote work culture or implement flexible working arrangements, it is essential to understand the risks and obligations that come with this shift. One of the primary concerns in a remote work setting is the risk of data and privacy breaches. When employees are working from home or other remote locations, sensitive information can become more susceptible to unauthorized access. To safeguard this from happening, we would recommend you thoroughly evaluate your data protection protocols and implement measures to mitigate the risks. We have put a couple of them on the screen. I've picked out 3 that we see as quite important to go through today, but we have put the rest of them on the screen that we would recommend. The first one is utilizing secure collaboration platforms. So making sure if you are going to be using those platforms where everyone can engage, that they are ones that prioritize security features, such as strong authentication methods, role-based access controls, and activity logging. These communication channels should be enabling employees to be able to share documents and communicate without compromising that sensitive data. The next one is introducing encrypted communication channels. So this would be ensuring that all your communications, especially those involving that sensitive information, are encrypted. This can include, emails, instant messaging, and video conferencing. And the last one that we have picked out is conducting regular staff training. So this training is really vital for educating employees about data protection best practices. Regular workshops can cover topics such as recognizing phishing attempts, securely handling confidential information, and understanding the importance of strong passwords. You should also be informing your employees of the latest cyber threats and scams that may target remote workers.
Yeah, so another consideration concerning compliance for managing remote employees is a question we're currently asked a lot from our clients is who is liable for the associated costs when working from home. For example, equipment such as laptops, mobile phones, computer screens, computer chairs, and office setups. In the McKeenan versus Red Energy case, the Fair Work Commission reviewed a claim by Mr. Keenan, who alleged constructive dismissal after his employer, Red Energy, refused to reimburse him for a desk needed to work remotely from home. He was employed in a computer-based role and he had phone work, and Mr. Keenan was allowed to work in the office when remote work was encouraged in March 2020 because of the pandemic and due to the lack of desk at his home. In May, he requested reimbursement for a desk, which Red Energy declined, though they continued permitting him to work on site. However, in July 2020, during the Victoria Stage 3 lockdown, Red Energy directed all employees to work from home. Mr. Keenan's union argued he lacked that essential equipment, such as a desk for safe home working, and subsequently Mr. McKeenan resigned, claiming he was denied a safe workspace, citing that pretty much Red Energy's obligations under the Occupational Health and Safety Act and WorkSafe guidance for employer pandemic preparation, which included providing necessary resources for remote work. The Fair Work Commission rejected Mr. Keenan's claim. In respect to the safety issues, the Fair Work Commission found Red Energy had actually provided a sufficient equipment to allow Mr. Keenan to work from home. While it did not provide Mr. Keenan with a desk, Red Energy provided him with a laptop, a headset, an adjustable chair, ergonomic assessments, and access to occupational therapists and online resources. So with reference to Mr. Keenan's computer-based job, Red Energy believed it was not fair and reasonable to provide Mr. Keenan with that desk, and the Fair Work Commission noted that Mr. Keenan's resignation communication did not refer to any element of compulsion to resign, as there was none. Instead, the Fair Work Commission actually found that Red Energy acted reasonably and it found that Red Energy's refusal to pay for Mr. Keenan's desk did not force him to resign. The Fair Work Commission ultimately rejected the claim altogether, finding that there were other options to the employee before resigning, such as borrowing a work desk. So really, in summary, from this case, we can see that when an employee's position is home-based, it's still really important that the employer's responsibility is that they do provide all those necessary supplies and access to effectively perform their job. However, it's really important to note that these requests remain reasonable and aligned with the company's capabilities.
Thanks for that, Amy. Now we'll go into another consideration around compliance for employers when managing a remote-based team involves the legality surrounding surveillance. Australia doesn't have an absolute right to privacy. However, there are specific workplace surveillance laws that are state-based in place to regulate monitoring practices. These laws can vary by jurisdiction. However, the key, most, I guess, strict laws currently apply in New South Wales, ACT, and Victoria. We have put all of the state-based surveillance on the screen, but we'll just go over the ones with the most requirements. So in New South Wales, the Workplace Surveillance Act, employers are basically required to provide employees with a minimum of 14 days notice before any surveillance is implemented. This includes activities such as monitoring computer keystrokes, recording conversations, and optical surveillance. Only notice is required here, and employers are not required to get prior consent from the affected employees. The notice must also clearly outline the nature of the surveillance, its purpose, and how the information collected will be used. Similar to New South Wales, the ACT is under the Workplace Privacy Act 2011. They must also give 14 days notice of the intended surveillance. Again, this is including the keyboard strokes, optical, and listening to phone calls. It has to address the details of the planned surveillance and also invite workers to consult with the employer as to basically why they are wanting to implement this surveillance. It also, however, imposes a further specific requirement that any data that is basically being surveillanced must be in accordance with a workplace policy on surveillance. The policy must state how the employer's computer resources, such as emails and internet access, may and may not be used, what information about the use of the employer's computer resources is logged, and who may access that information, and how the employer may monitor and order a worker's compliance with that policy. And the final one is in Victoria, which is the Surveillance Devices Act 1999. It outlines restrictions, and according to Victorian law, it's offence to use optical surveillance device or record or observe a private activity without the express or implied consent of the parties being monitored. In addition to that, it's also an offence to knowingly install, maintain, or use a tracking device to track the location of a person. For example, this could involve tracking devices on a computer to track their location when working remotely. The final point we'll discuss within compliance around managing remote teams is a new entitlement that was introduced in August this year. Employees are now entitled to the right to disconnect following significant amendments under the Fair Work Act. This clause was added to all awards. The new legislation aims to establish clear boundaries around out-of-hours work communication. For any small businesses on here who were in business on this date, the right to disconnect will come into effect a year later on the 26th of August, 2025. The key aspects of this new legislation include employees now have the right to refuse to monitor, read, or respond to work-related communications outside their regular working hours, provided that their refusal is not deemed unreasonable. The assessment of whether an employee's refusal is considered reasonable takes into a few considerations. The first one is the reason for the contact. The second one is like any potential disruption to the employee, if the employee is being compensated for the contact, the employee's roles and responsibilities, their personal circumstances, and any legal requirements for that contact. If there's any disputes that arise regarding the right to disconnect, they can be brought before the Fair Work Commission and they can make orders to prevent employers from taking disciplinary action against employees for potentially not responding to the contact, or conversely determine if the employee's refusal is unreasonable. In some situations, however, employers may be required to monitor, read, or respond to contact from the employer outside of their working hours, and information on the reasonable means for contact can be found within the award that the employee is covered by. For an example, when an employee is paid an on-call allowance, this would be considered a reasonable means for contact because the employer would only be contacting the employee to let them know of like the work that they're needing to go to or where it is. It also may be reasonable to contact an employee regarding emergency changes in rosters.
Thanks, Georgia. So, as we discussed earlier, there are a lot of benefits to introducing a remote workplace culture, but with that ever expanding list of benefits, there are, of course, risks and challenges that the employers will face. So, this leads us to our next topic, which will discuss managing misconduct and performance when working remotely. With the lack of visible supervision, surveillance, and remoteness of remote work will mean that some employees will have time, freedom, and motivation to see what they can get away with. These behaviours then may escalate as boundaries can be pushed and conduct is not detected or managed. With it can come serious risks to the business, like its intellectual property, potential financial loss, or financial disadvantage, and even the welfare of your staff. We'll put some examples down of employee misconduct, which you can see on the screen. I'll go over a few of those points. One of them could be leave creep or time theft, where staff don't take leave entitlements because they can hold themselves out to be working. Another one is being under the influence of alcohol or other drugs. Another one that we do see is engaging in inappropriate secondary employment. So if they have another job while trying to work remotely for your business there. If your business is using remote work or considering it, it's going to be really essential to have those clear policies in place. We recommend starting by setting up policies on misconduct, such as what actually constitutes that misconduct, having a discipline and termination policy, and really clear remote work guidelines. Together, these policies will hopefully clarify what you expect from the employees working remotely and outline the consequences for any misconduct if the employee decides to engage of any of the behaviours listed on the screen.
Thanks, Amy. Now, if when working remotely as an owner, you do find yourself in a situation where you have had your employees engage in any of that type of behavior, we'll now guide you through what the recommended steps are to address the misconduct. So typically, as a first step, the business will need to assess what the most appropriate process is to follow. This will obviously depend on the nature of the alleged conduct. As an example, if you have a situation where potentially you've noticed your employee log on for work late 2 times within a week, or they've left early and they haven't told you why. The recommended approach, rather than going straight to a disciplinary meeting, would potentially be to informally meet with them and have a discussion with the employee about why they're logging on late. You know, your expected starting and finishing times are this and this. If you are going to be late, you need to inform us. And after that, we would always recommend that you send an email to the employee just confirming your discussion and also setting the expectations for moving forward. However, if the allegation is more of a serious nature, such as potential bullying in the workplace, the business will likely need to undertake a formal investigation into that allegation. Not all allegations of misconduct will require investigation. It may be blatantly obvious that the conduct has occurred, but generally speaking, when doing an investigation remotely, you would need to take statements from the complainant interview any witnesses that were named or involved in the conduct, interview the respondent, and pending on the outcome of the investigation, if it's found that bullying did occur, move to a disciplinary meeting. Once you're at a stage where you have investigated the allegations and they have been substantiated and you're ready to proceed to that disciplinary meeting, we'll first, before we do that, need to assess the risks to the business. So there's two main risks regarding to claims that can be made against the business when going through disciplinary action if the outcome involves a warning or termination. The first one we'll need to assess is if the employee has unfair dismissal access. So an employee will automatically have access to unfair dismissal if they've worked within a small business, which is less than 15 employees for 12 months, or worked for a large business, which is a business with 15 employees or more for 6 months. Now, a dismissal is deemed as unfair if it's considered harsh, unjust, or unreasonable. There is a criteria for assessing this. I'm going to read out some of the key points. However, there are some more that will need to be considered, but I'll just go over the main ones. So the first one is whether there was a valid reason for the dismissal related to the person's capacity or conduct, whether they were notified of that reason, whether the person was given an opportunity to respond, if there was any unreasonable attempts by the employer to basically refuse them to have a support person there, and if the dismissal was related to unsatisfactory performance of the person, whether they had been warned about that performance prior to the dismissal. Dismissing an employee in breach of any of those protections can result in the employee being reinstated to their pre-dismissal role, the employer being ordered to compensate the employee. The amount for compensation for this that can be ordered by the Fair Work Commission is capped at around 6 months' pay. The second claim that an employee can have access to is a general protections claim, and this can come in at any stage of the employment. So even pre-employment when you're in an interview stage, all the way leading up to when they are fully employed by the business. Basically, what this claim is where an employee, and it protects an employee from having adverse action taken against them, such as, being terminated or given a warning or taken off a shift or, told to come back into the office because they have exercised a workplace right or they hold a protected attribute. So on the screen, you can see some examples of a workplace right. Some of them will include an employee taking sick leave, an employee going on mat leave, an employee making a complaint or an inquiry about their pay. The protected attributes that you can see on the screen, they can relate to, so they're all included there. You've got race, color, sexual orientation, and so on. If an employee is terminated or has had adverse action taken against them, which is in breach of any of these protections, this can result in a range of orders being made against the employee, including reinstating the employee, compensation for economic loss, which is uncapped, and also compensation for her stress, humiliation. Now, if you have identified that your employee holds any of these risks above, we would always recommend assessing how high that risk is before proceeding with disciplinary action. And also, if you have a genuine reason for the termination or warning or bringing them back into the office. With unfair dismissal, if you follow the correct process, such as the considerations I mentioned prior, which includes, having the valid reason, allowing them to bring a support person, giving them time to respond, and you follow all of those through, generally it can reduce the likelihood of a successful claim. As for general protections, as long as you have a valid reason and the conduct has generally occurred, it will also reduce that successful likelihood of a claim. For example, if you have had an employee who has just, requested to go on maternity leave or informed you that they are now suffering from an illness or a disability, that would potentially be seen as a high risk scenario to take any action against them unless you had a genuine reason. So unless there was an obvious misconduct or performance issue going on, basically you would have to prove that the reason for the dismissal or warning or adverse action was not because of that disclosure and it's purely directed to the misconduct. With general protections as well, there is a reverse onus of proof on the employer. That basically means it's up to the business to disprove the claim that the reason was because of the protected attribute or the workplace right, and it has to be directly related to that misconduct. Once you have assessed those risks, we can move to a disciplinary meeting, obviously pending the outcome of the risks. Broadly speaking, there's 3 stages to this process. This is a very high level overview of the disciplinary process. However, please seek advice if you're unsure of how to proceed, or if it is a high risk scenario, we would always recommend that you get HR advice either from us or from whoever you use as your HR resource. First of all, invite the employee to the disciplinary meeting to attend officially in writing. The invitation needs to set out the allegations that are being made against the employee, including the details of the date of the alleged conduct that had occurred and the exact alleged conduct so that the employee can properly prepare for their response. The invitation should be given to the employee 24 to 48 hours before the meeting, and the invite should also outline that they can bring a support person if needed. Secondly, hold the meeting. So this is obviously that 24 to 48 hours after you've invited them. We would recommend that you bring another person into that meeting to take detailed notes of what is discussed, present the allegations to the employee, and allow them the opportunity to respond. If termination is a potential outcome of this process, this also needs to be strongly communicated to the employee during the meeting. Third, once the meeting has been concluded, close it off. You'll need to generally consider the employee's response to the allegations in that meeting. After some time has passed, there's no set time on this. It really is just pending what the employee says. Obviously, the employee has nothing to say and says, yeah, I did it. That's not really gonna, it may not be, it may be reasonable to give them an outcome later on in that day. But if they've got a lot of reasoning as to why that conduct occurred, you will need to generally consider that. The outcome that you provide to the employee, it should be fair. You should hold another meeting separate to that. It's always best to provide the outcome to the meeting when working remotely over Zoom. And you should also be providing the employee with a copy of that outcome, whether that outcome is going to be a formal written warning or a termination letter. So that's misconduct. Now we'll go into underperformance. When dealing with remote-based performance concerns, it's essential to first identify whether it is a will or a skill issue. If it is more the employees willingly acting and doing certain behaviors, it's more than likely it's going to be a misconduct issue like described just before. If it's related to their skills, then it's likely going to be considered underperformance. So underperformance can look like different things for different roles. Some of the things that it can include are on the screen there. So not performing duties or not performing them to required standards. And when dealing with these concerns, we've also got some common reasons for the underperforming. There can be many reasons why they're underperforming. Some of them can include low personal motivation or confidence. Maybe the employee doesn't know what's expected of them. They're not, entirely sure because the standards are unclear. And also there could be other things going on in their personal life as well that are affecting their work. Before addressing the underperforming employee, the first thing to do would be assessing if the goals and standards and objectives have been made abundantly clear to this employee. So this could be done by way of job description or clearly defined KPIs. If you're confident that you have those in place and you've clearly outlined to the employee what their expectations are, you should informally meet with them initially before going to a formal route to basically discuss your concerns relating to their performance. You'll need to outline the specifics in relation to their performance. So maybe they have a task that they need to send 3 emails out to clients every day and they haven't been doing that. You will need to be that specific and say, your expectation is this, you're not doing that. We have concerns, and asking them at that stage, is there anything that's preventing or hindering you for doing that at the moment? Maybe they might need some additional training. Maybe they don't know how to do a process. This is what this informal discussion is all about, for you to get an understanding of what's going on and for them to know that you have concerns about their performance. Following that initial discussion, We recommend to send out an email, basically recapping everything and outlining your expectations from moving forward. If it's further training that they need, outlining what's going to happen there as well. Once you've addressed this matter informally and have noticed no improvement, or maybe further things have popped up that you've noticed have been going on since that first informal discussion, then it may be appropriate to move to managing the matter formally.
Yeah, so now we're just going to go over what that formal performance management can look like. So managing underperformance at the formal stage has no set process, as it'll typically depend on each scenario. When managing performance informally, it will typically involve a performance improvement plan, otherwise known as a PIP. We've put an example PIP on the screen for you to look over there. If you're going to be issuing a PIP, the usual period for this plan is around 6 to 8 weeks, depending on how thorough you want to be. It's going to ensure that the employee has reasonable time to implement the changes and improve their performance. The plan should also be made in consultation with the employee and ensure that the requirements are actually achievable and measurable. Once you've implemented the plan, you should set regular check-ins with the employee. And if there are any issues that arise during the plan period, that they're addressed with the employee at the time and not being left right until the very end. After the PIP has been completed, you should meet with the employee to inform them how they went. If the PIP is successful, you can basically just close that off and continue to encourage their performance. But if they haven't achieved those outcomes in the PIP, typically we would recommend to proceed with a first formal warning and then issuing another PIP. Following the completion of another PIP, if the employee has not improved, the business will likely be in a position to terminate if there's no risk of general protections claims. So when addressing misconduct, clients often ask us if they can require employees to return to the office if they observe underperformance or misconduct. Generally, an employer can actually request an employee to return on site if their contract specifies the office as the designated work location. So reviewing that employment contract is going to be really essential, as it's going to outline the employee's agreed upon work location, and it could also include some clauses regarding the employer's right to make reasonable changes to the work arrangements. If the office is the specified work location, then directing the employee to return to the workplace is typically going to be within the business's lawful rights. However, you do need to note that employees still retain that right to request flexible working arrangements, and if they can provide that supporting evidence for their request and there's no unreasonable hardship on the business, you may still need to adhere to those requests. We wanted to share a case about flexible working arrangements that highlights how important it is for businesses to follow their own policies. So in a recent case involving Queensland Health, it highlighted the importance of adhering to their own flexible work policies. In 2021, a manager requested a full-time work from home arrangement, which the employer partially approved, requiring 50% attendance. The manager appealed, arguing that the blanket approach overlooked his specific circumstances, despite the company's policy to support work-life balance and tailor flexibility individually. The court ultimately ruled in the manager's favour, allowing him to work from home 4 days a week, emphasising that employers must assess each request based on individual needs rather than applying a general rule. So this case really just shows the need for employees to follow their own policies really carefully and ensuring each flexible work request is considered on its unique factors to promote a fair and supportive work environment, and not just taking that one size fits all approach.
Sorry, I was on mute. Thanks for that, Amy. The last one we have is in regards to a case that was put forward from Samarsi Construction Group. Was basically terminated in October last year after refusing changes that required her to work from the office. Essentially, to recap the case, she was hired to work from home, and this was basically an arrangement that happened pre-COVID, due to caring responsibilities. And then essentially the employer notified her that her role was now required to be in office, as they no longer could facilitate her from being from home. They basically sent her a proposed restructure and offered her that office-based role in a completely different role, which she declined. And the employer basically argued that her refusing that request essentially meant that she wanted to end her employment. And they put down ineffective communication and performance issues tied to remote work as dismissal reasons. However, as I mentioned, that work from home arrangement was before pre-COVID. The dismissal process was flawed. She was neither informed of the reasons or given a chance to respond. Ending liquidation, but they actually awarded her $5,000 in compensation and basically emphasized the need for fair communication procedures whenever you're going to be changing an employee's role, even if you're doing it from home. So that was basically the end of our webinar today. Thank you so much for everyone for joining. We have seen a fair few questions pop up in the chat box, so we'll move on to them. However, if we don't get to all of them, don't worry, we may send out a sheet after, just covering everything off. Okay, let's go through some of the questions.
Okay. I can see
So
one here, Georgia. So someone's asked, would it be reasonable to say no to a work from home request if the employee's work product or their output was not meeting acceptable standards, or if they were being performance managed? So as we mentioned before, it's going to be really important to look at the contract. If in the contract, you can see that their work location is actually in the office, you may be able to direct them back into the office. The only thing that you'll need to consider is if they have a right to request that flexible working arrangement, and if they've provided evidence of that, you would essentially need to prove that that request for working from home in line with that flexible working arrangement would cause undue hardship on the business. So yeah, essentially you could direct the employee back into the business if they are underperforming. You just need to make sure that that's within the contract and that they don't have any protected factors there.
I can see another one from Nancy. Do you provide a template for working from home setup checklist? Yes, we definitely do. We have a remote work checklist. We also have a remote working policy that outlines expectations. So we definitely do have one of that. Another one from Sue. The question was, we have one optional work from home day on a Tuesday that we allow. We provide laptops and headsets. We do not supply chairs and desks. Is that a risk to us? The only risk I would say is if your employees are sitting on a chair that's potentially not a suitable chair to be sitting on, then they may injure themselves on that chair. So a way to combat that would be, and we actually do it at Employment Hero, we have to send a photo of our work from home setup that clearly shows, where the computer screen is, what our desk looks like, what our chair looks like. If you aren't going to be providing a chair, that's completely fine. However, I would potentially be checking the setup that your employees do have. So that way, if they are potentially, sitting on a lounge or sitting in their bed or something like that, it's probably not going to be the best for their back and is potential to cause injury. So that is a way to circumnavigate that, because you don't necessarily have to, but it just depends on the setup.
Yeah, so I can see another one here that asks, if your business provides flexibility to work from home, but it's not mandated, is the business still liable for ergonomic assessments or furniture required? The answer is essentially going to be those work health and safety laws are still going to apply no matter where your employees are working. If they're working remotely, you're still going to be liable to ensure that they are healthy and working safely from home or remotely. So the business may be liable for those ergonomic assessments if you are doing those risk assessments there. And if the furniture is a requirement for them to be able to fulfill their role. But as we mentioned in a case throughout the webinar, it's going to be whether that request for furniture is actually reasonable and related to their role.
Thanks for that, Amy. We have another one from Rebecca. So the question is, how do you implement remote and flexibility work practices into businesses that are predominantly operational? You've mentioned the example of your forklift drivers can't be able to work from home, and admin staff can, and how to basically do it without that divisional, I guess, happening between staff. It is kind of a hard one because obviously businesses that are fully operational and they are required to be, working on the tools or working in a warehouse, there's not really a way that the employer can do, like, you can't really do that role remotely. So I think, unfortunately, the conversation would have to be, look, we're moving parts of our business to work remotely. It's only going to apply to those employees that have the ability to work from home. Unfortunately, if you're not in one of those roles, we can't facilitate it, because if you're working in a warehouse where they need to count stock, it's not really going to be reasonable for them to bring stock home, or that type of setup. So I think it would just have to be one of those kind of awkward conversations that basically sets an expectation that this is a role that you're in, and unfortunately we can't facilitate that from being from home.
Yeah. I will just answer one more here. So someone's just asked, Russell's asked, just to clarify, if an employee has 12 months completed service, are they automatically entitled to qualify for flexible work arrangements, or does the employee have to also meet one of the other listed qualifying conditions, such as being caring for a disabled child? So essentially, yes, if they have the 12 months service, they also need to qualify under one of the protected factors, such as going through family and domestic violence or being over 55 years old there. So it's not just if they've served, they also have to meet one of the protected factors there as well.
Perfect. Well, that was all the questions that we had time for today. Thank you all so much for joining. We hope that you got a lot out of this webinar. Just some additional points. If you are potentially struggling with managing remote work, or you're looking to move to a managing remote work arrangement, and you're needing some help, please reach out to us at Employment Hero. We are definitely here to help with those type of scenarios. A survey will automatically launch after the webinar. We would definitely appreciate it if you took a minute to please fill it in. And we'll also be sending out some additional resources along with the webinar recording after today's session. So thank you everyone once again. We hope that you enjoyed it, and we hope you have a wonderful afternoon.